Coming up on this program, we show you how to get connected. Find out how to choose an internet service provider. Discover the newest form of communication, electronic mail.
Ways down and ready to ride. One by one, billion by billion, been holding up half the sky. Raise your hand if you're ready and willing, if you know it's time. Time for a girl on fire. Time for a girl on fire. Time for
Hello, 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 everybody. I hope you are all well. Hold on. I really have to pause this so that I don't get doubled up. Hi, howdy, Hector. Hi, Vicky. Hi, Rose. Lindsay. I forgot to put my eyebrows on. Whatever. I forgot to finish my eyebrows. You know, when you just, like, look... Maybe you don't know what it's like when you just look in the camera and you're like, oh yeah, that's what you wanted to do. Anyways, it doesn't matter though. Maybe she's born with them in different time zones. I'm still reminded, and I still tell the story about the twins with different dads. We didn't get to cover it on this channel yet. I still hope to get that and do that. But what I do have today is some court for us to watch. Now, I have not watched this. Raw dog yoga. Hold on. A lot's happening here. Streamlabs. Firstly, what's going on? Brooklyn came into the crew. We love it. Thank you, Brooklyn. Shane, the notification was only just 12 seconds ago, so you didn't miss much. And then we have Christopher Engleby, aka Raw Dog with 2 G's. Yogurt 2025, baby. Hi, Christopher. I love you too, my friend. I was thinking about you. I saw you in Credence and Mikey earlier. Chuck was there too. Vicky was there. You know how it goes. Hi, Donald. So guys, I do not know why that did not say thank you properly. Why? But I appreciate it. I thank you. Raw Dog Yogurt 2025. Christopher, you're always making me laugh. I love it. Yes, cellulite yoga pants. Please like, or the YouTube fairies will shove earplugs in your nose at night. Okay, I'm not sure that I condone that one. But anyways, I'm just joking. I've been known to smother a person or two to get them to stop snoring. It just looked like I've been live for a while, does it? Is it because I'm wearing like workout clothes and I look sort of exhausted? Because here's the truth. I've worked all day, but it's 3:57. Billy's here now. Courtney's here. Courtney sent me a picture of a fucking huge snake in her yard. But anyway, so I would love to do a proper walk later today and get my steps to 20,000. But that depends on what this court is, and I'm going to be honest with you guys. I have not screened this yet. I have not even watched a little bit of it because, like I said, I've been out all day. So let's watch it together. I'll be honest, I zipped through it to get a thing for the thumbnail and to try and understand what they're talking about. So I think it's about a will, but I wouldn't be surprised if I was fucking wrong. Just gonna be honest about it. Anyways, you guys, tell me, while we're just gathered here, I want you to know that I love you, but also just tell me what you have for dinner. If you didn't like what you had for dinner, tell me what you wish you had for dinner. What would I wish for dinner right now? If I didn't have to cook it. The problem is whenever I wish for something, I'm the one that has to cook it. I mean, it's Tuesday. Tacos are Tuesday things, but let's see what this case brings.
A little scary. Not, I wasn't, no weapons or anything. I wasn't threatened or anything. It was just,
Overwhelmed.
overwhelming. Yeah, that's right. Yeah. 10 o'clock in the morning. Trying to go to my hotel, just
Well,
wheeling my luggage.
Thieves don't get up that early usually.
Yeah, that was, well, you're just, I think, just a little bit dazed and confused, when you're traveling, maybe that first day, so anyway, I'm over it. I appreciate everybody's, I
You're supposed
appreciate
to travel. You're
it.
supposed to travel with a buddy.
But my wife was right there, but she was ahead of me. She kind of took some responsibility, said that if she had been by my side, then it wouldn't have happened, but she's probably right. But she
You
was
never
anxious.
know.
She was anxious to get to the hotel as well. But I do appreciate everybody rescheduling the argument.
And that's you at home, people. We're thankful for you too, especially Raw Dog
Grease it
Yogurt.
on.
Yep.
Yeah, no.
We have everyone we need.
I think
Believe
so,
so,
Judge.
Your
I'm
Honor.
here.
I think so, Judge.
This is in the District Court of Brooks County, Kansas. Case number 24 CV8. This is Nancy Bea versus Gregory Wishman et al. May I have an announcement of appearances, please?
The plaintiff, Nancy B.A., appears by and through her counsel, Brad Manson. I believe that Ms. B.A. is also on this call, although I don't see her picture. Sure, her video and audio are probably muted.
Hello, I'm here. Good
Okay.
morning.
Good afternoon.
Plaintiff appears personally and with counsel Brad Manson and Austin Manson.
May it please the court, Kay Bryn appears for Johnny Keller as executor of the estate of Berdina Wistman, Johnny Keller as executor of the estate of Carol Wistman, and Brian Kimling, Jeffrey Wistman, and Johnny Keller as trustee of the Wistman Family Trust. And I see that Johnny Keller is also on the video.
Your Honor, I represent Gregory Wisman, Jeffrey Wisman, and Galen Wisman, appearing by Zoom by Don Hoffman, their attorney.
You're set for oral argument this afternoon. Mr. Manson, you filed your brief in support on January 31st. I've got that. As well as Ms. Bryn, you filed your brief on February 20th. Mr. Hoffman, your brief is from March 7th. And then Mr. Manson, your reply brief is from March 25th. Are there any other documents we need other than what's attached to Mr. Hoffman's response?
There's no other briefing except the briefs that you've recited.
Your Honor, you requested one after I sent mine in. Do you remember what that was?
Yes, I had requested the actual trust.
Oh, of Berdina.
Yes.
The court requested, I think, the third amendment. I downloaded to you the original trust document and then each of the amendments, so you should have those. And I think you also asked for a copy of maybe Berdina Wistman's will or one other will document.
Well, on Mr. Hoffman had filed the will of George Wistman. And at the bottom, it cuts off the end of paragraph 8, and on page 2, it starts in the middle of paragraph 9.
Oh,
So I don't have the end of paragraph 8 or the beginning of paragraph 9.
well, I think you requested then a copy, full copy of his will, and I think I included that in my download to you. But in any event, Judge, George Wisman's will is attached to our original petition, I believe. In any event, the original will was filed in the estate of George D. Wisman, which is Rook County case number 2006 PR 53. And the original will was filed of record on November 2nd, 2005.
Just had a brilliant
But we all
idea.
have it, Judge. We can all download Mr. Wisman's will to you.
Everybody's wills are downloadable now. Duh. To write it down. Thank God I have these giant post-its that Christopher Engelby got me, and I can write down this idea. Yes.
I don't see the will attached to the original pleading.
Then I misspoke, Your Honor.
And you said you've sent it to the parties?
Well, I sent to you whatever it was that you requested. I don't recall in your email whether you requested Mr. Wisman's will. But if you did, I sent it to you. But we can send it to you right now if you'd like.
Yeah, I'm not finding it.
We'll email it to you right now.
Okay.
We'll email you the will. We'll email you the will. Christopher, I use what you give me all the time, and I'm using the post-its, the giant posties. I can't show the idea, though, because I'm going to implement it. I don't want somebody to steal it. Do I have any glass straws left, Shane? Thank you so much for that question. I'd like to point out that I have broken 0. Literally 0. But I'll be honest, I've also avoided washing any. So I still have 4 that are unused and that I may, I could still use, but I am afraid that when I do wash them, I may break them. That's a trigger point. But you know, I made myself a video. I'm kind of acting crazy. Really? I'm just waiting for the judge to get this email about a will. But anyways, they're all intact at this point. Luckily. If you're wondering what I'm talking about, I bought some glass straws recently because my sister gave me 2 of them and they fucking broke immediately, basically, because I am rough on things. But these ones are thick and they've worked quite well. Hi, Beverly. Also, Adam, 101 degrees in Austin. That's terrible.
We just sent it to Ms. Heilman's email.
Okay.
Please
Your
don't say
Honor.
her email, dumbass. When I was in Texas 2 years ago, it was 110 in Houston. But, you know, I was discussing with a friend today about why the weather in where I live
Brad,
has
if
really
you're
high
sending
humidity,
that,
but
could you
not.
also send it to our office as well?
Yeah, copy Dawn, and yeah, we did, Dawn.
I've got one, but it's kind of cut off after paragraph 9.
Okay.
Cut off after paragraph 9. This is actually what law is, guys. God.
I've got the same one that was attached to my brief. No, I've got the full.
Nothing about this is brief, you idiots.
But 8 is cut off.
I'd like to see the end of paragraph 8, the
Yeah,
first
it is cut off.
paragraph 9.
Okay. Oh, she's magic. Sorry, I just had another great idea. Whew.
Jess,
Anyway,
did you
so-
receive that?
Judge, I was explaining that the humidity here is 85%.
Yes, Judge, I forwarded it on to you.
There it is. Okay.
Oh my god. Read it in silence, Judge. Ugh. Anyways.
The court on March 15th sent all counsel an email, and it's dated March 15th. You wrote that you cannot locate the Wisman Family Trust, only the Third Amendment, nor can you locate Berdina Wisman's will. So I sent those to you, I think on Tuesday or Monday, the 17th, or Tuesday, the 18th. But that did not include Mr. Wisman's will.
All these people are dying. It's terrible. How much money you think we're talking about here? Enough to get all these lawyers involved. That's enough. We just have to up it to
I reviewed
1.25.
that now. Mr. Manson, are you ready?
Yes, sir, I am.
Go ahead, please.
Judge, we're here to really go to the heart of the matter of this lawsuit, and that is whether George Wisman's children, also Berdina Wisman's children, whether the two that predeceased Berdina Wisman, which are Darren and Carol, whether their deaths terminated their remainder interest in the property from George Wisman. So that's the issue before the court. And we believe that Mr. Wisman's will, having omitted the language that you would find in wills of this nature, that the remainder should go to the children, and then to decedents of any deceased child or children to take the parent's share, that kind of language. I just read from the Ferris versus Nickel case, which is 152 Kansas 652. It's a 1940 Kansas Supreme Court case. And that court cites the Jacob Nichols will that had that provision in it, and it used that provision as a key to deciding which of Jacob Nichols' children, or one had predeceased the termination of the life estate, which one should inherit under the will. So in George Wisman's will, you'll find and see in paragraph 7 that it says, it reads, I give, devise, and bequeath unto my wife, Berdina R. Wisman, the use, income, and possession of all the rest and residue of my property, real, personal, and mixed, whatsoever and wheresoever situated, which I own at my death, for and during her lifetime. And this is the important phrase then. With remainder therein to Nancy S.B.A., a 1/3 interest, Carol K. Wisman, a 1/3 interest, and 1/3 interest to Darren Wisman. If you read the remainder of paragraph 7, which I will not read right now, there is no language then passing that remainder interest to Darren or Carol's children if Darren or Carol do not survive their mother, who had the life estate. If you take it back just a step further, prior to George Wisman executing his will, Mr. and Mrs. Wisman retitled the property of their farm from joint tenancy to tenants in common. And they did this, I'm interpolating here, but they did it so that Mr. Wisman could leave his half of the property as set out in his will, and Berdina Wisman could leave her half of the property as set out in her will, which in fact is what happened. So in the interim, so when George died, and George's will was executed on May 25th, 2006, it was prepared by counsel. It was prepared by Mr. Sakanik, an estate planning lawyer in Stockton, Kansas. And Mr. Wisman died about 90 days later on August 30th, 2006. I don't know whether he was suffering from a terminal illness when he executed his will or not, but the timing would seem to suggest that he knew that his death was coming. In any event, it's about 90 days after he executed the will that he in fact died. Then his wife Berdina was his executor and filed the original will on November 2, 2006. I think actually Mr. Sakanik filed it on her behalf. So the George at the time of his death owned an 1/2 interest as a tenant in common in about 6,500 acres, virtually all of it located in Rooks County. And he left a life estate to his wife. And if you read the remainder of paragraph 7, during the life estate of my wife, Berdina Wisman, she shall have the exclusive power and authority to lease such property for oil and gas purposes without the signature of any other person, and shall have the right to receive and retain the bonuses and delay rentals in connection with any such lease or leases. And in the event production is discovered on said land, she shall receive all the royalties paid in connection with and during her lifetime. My wife, Berdina R. Wisman, shall likewise have all of the income produced from said property during her life, subject to the payment of taxes and expenses on said property. I provide that any property in the residue of my estate can be used for the payment of debts and estate taxes. My executor, which was his wife, shall have discretion to determine what property should be sold and to satisfy death. It is that language that created the life estate, in addition to the language that I quoted earlier above, which gave all of the residue of his estate to his wife during her lifetime. So it created what we commonly refer to as a life estate. So George owned 1/2 of the property. Berdina owned 1/2 of the property. Berdina owned 1/2 of the property at George's death, outright and absolutely. It was her property. And George's property then was subject to the life estate of his widow, Berdina, which she used and utilized and enjoyed until her death at over age 100, some many years later. But prior to Berdina's death, her son Darren died and her daughter Carol died. So our belief is that the court is required to interpret the will. I don't think there's any interpretation really required. Is required to read the will with the testator's intent. And here, the testator very specifically excluded a gift over to the heirs of any children that predeceased him. And if you look elsewhere in his will, you find that there's, for example, a no contest clause, so that anyone that contested the will would not be able to inherit an interest. It also includes in a couple of places requirements that if any of the property is sold, that a member of the family be able to bid on the property. And we believe that that means his children. And this is further supported by the specific bequests given to the defendants in this case. So if you look above in paragraph 3 of Mr. Wisman's will, you'll see that his grandfather gave Gregory Wisman all of the shares of the First National Bank stock that he owned. And then he gave to Darren, his son, a specific Kenilworth truck. But more importantly, in paragraph 6, he gave to Gregory and Jeffrey, Jeffrey, and Galen specific bequests. So one of the things that I believe courts look at when they look at wills is, was a child omitted from the will? Was a grandchild omitted from the will? And was that an error or was that intentional? But here you have a very specific intent to recognize the grandchildren because specifically the defendants, Gregory, Jeffrey, and Galen, are left specific property by their grandfather. So it was George's intent that his children own the property and not his grandchildren. He could have very easily said, as the language in the will that was at issue in Nickel said, to have and hold during the term of her natural life with remainder at her death to my children, which is almost identical to the language we have here, in fee simple forever, the descendants of any deceased child or children to take the parent's share. And that language is not in Mr. Wisman's will, nor is any language similar to that in his will. Sometimes you'll see language that would say the heirs and devisees of my children should take their parent's share, that kind of language. That language is not here. And that is specifically why you wear the black robe and have the responsibility to make the legal decisions. Kansas courts have not yet determined what effect not including a gift over to one's heirs has on the testator's intent. But then again, going back to this Ferris versus Nickel case, which is really the only case that's on point, and it's cited by both parties. Ferris v. Nickel says at page 721, a remainder may be vested subject to complete defeasance. And that's what we're saying occurred here. And if you read the language in Mr. Wisman's will, it says with remainder therein to Nancy B.A., a 1/3 interest, Carol Wisman, a 1/3 interest, and a 1/3 to Darren Wisman. Those were his 3 children, and also Berdina's 3 children. So Ferris also says words, phrases, or clauses requiring survival can either explicitly state through words such as who survive or who are living at the end of a prior interest or other period of time, or they may be determined by language having the same import that a requirement of survival exists and that such survival is a condition precedent to such interest. And they cite the restatement of property, the one that was in existence in 1940, which in this sense, in our research has not changed. So we believe that the court does not have to interpret the will. The court does not have to include language in the will that isn't in the will. The court doesn't have to imply language and should not imply language in the will that is not in the will. And so at the death of Darren, then his interest in his mother's life estate created by his father terminated. And when Carol died prior to her mother's death, all of this being terribly unfortunate, obviously, then her interest terminated. So there is a survivor, and that is the plaintiff here, Nancy B.A. And our belief and the argument here is that under George Wisman's will, Nancy B.A. inherits all of the interest of her father, George Wisman, in his 1/2 of the land. So,
oh my god, it's like a miniature ice shot glass, you guys. Look at this. It's holding the pop perfectly. Oh, it's once in a million. It's like when I got a taco chip. Oh, I'm gonna do a little shooter. Shots, 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 shots. You know, we dream and we dream. And we dream of a day. We dream of a day like that. This guy's talking about fuck God knows what, and I'm in here with a goddamn miniature shot glass ice cube in front of me. What a time to be alive.
George explicitly gifted specific items to Darren's children and other parts of the will. Carol never had any children. So Carol Wisman died without children. She created a trust. Ms. Brin drafted that trust, and Nancy B.A. is the beneficiary of that trust. But if Carol's interest terminated, then that trust would not be funded. He left specific items to his grandchildren, which proves that he knew how to designate heirs when he intended to. The omission of the language "to their heirs" in the remainder clause for his three children signals a deliberate choice to exclude inheritance through predeceased children's estates. This precise language supports that George wanted only his named children, not their heirs, to take the remainder interest if they survive their mother. There's no substitutionary language for heirs, despite specific gifts to grandchildren elsewhere. The strongest argument for implying a survivorship requirement in George's will derives from the fundamental character of a remainder interest. A remainder, by definition, is a future interest that becomes possessory only on the termination of the prior estate. So in other words, Nancy, Carol, Darren did not have a possessory interest, did not have a vested interest until the life estate terminated. In this case, as a remainder interest, the share only comes into actual possession when Berdina's life estate ends. This structure inherently suggests that the remainderman must be alive to receive possession. A vested remainder interest is defined as the absolute right to receive title presently existing when the real property ends and is already in place, but that's not what existed here. That definition for a vested remainder interest presupposes a living recipient who can exercise this right. The specific language in paragraph 7 of George's will supports an implied survivorship requirement. George, stated what we've already quoted, that he leaves the life estate to his wife and the remainder interest to his children. This language creates a sequence of possession, not merely an abstract ownership right. The word remainder itself implies that something left over that passes to someone else after the first possession ends. This suggests that George intended living beneficiaries to receive these interests when they became possessory. Furthermore, the allocation of specific fractional interests, so just the way this would devolve down to different grandchildren, to a trust or whatever, indicates that George intended that his children specifically, not their estates or heirs, receive the shares. So then I mentioned the no contest clause that's in paragraph 10 of the will, and the first right of refusal that's in paragraph 8. That was maybe cut off in your prior copy, but now you have, as supporting this idea, this position, that the proper reading of Mr. Wistman's will is that if a remainderman died before the termination of the life estate, that remainder interest terminated. And so the only interest to pass at Berdina's death passed to only the children that survived Berdina. And that's our argument in support of our motion, Your Honor. This really goes to counts 2 of the petition, which is to quiet title. So if the court were to find, as we have argued here today, then that would quiet title to 50% of the land, and it would be in Nancy VA's name. And then this also goes, maybe it's duplicative drafting in the petition, but there is count 3 is for declaratory judgment. So this argument also supports a declaratory judgment request. We're asking the court to rule as a matter of law that George Wistman's will is as we've contended it should be read. So that's the argument that I have, Your Honor. Thank you for your time and attention.
Ms. Brin. You're muted, Ms. Brin.
You know what? Just keep it brief, ma'am. Just shut the fuck up,
She's
please.
muted,
You're still muted.
There we
think
go.
that's a sign.
So as executors and trustees of various entities, various trusts and wills, I don't believe it's appropriate to argue one position that would favor one beneficiary and be detrimental to another beneficiary. So our position is we believe there's an issue that the court needs to decide, but we are not taking a stand on the issue, and we're not making an argument, and we stand ready to do whatever the court decides.
Mr. Hoffman.
Your Honor, I would go with whatever I prepared in my brief. I just have some short comments concerning this. This life estate that was in George Wisman's will was a typical life estate with a life tenant. And a life tenant in Kansas has a duty to preserve and protect the remainderment. What the court first needs to look at is, number one, was there a condition precedent for this to vest in George Wisman, or I guess in Darren Wisman's name? There is no condition precedent. As a result of no condition precedent, that means that Darren's interest was vested as a future interest immediately upon the death of George Wisman. Now, all of the things that plaintiff's attorney has been arguing about that go to intent, if you want to look at intent, the intent is that there was George and Berdina intended for the Wisman brothers to have this farm. The only one that is interpreting this case as the intent being something other than that is just not true. You look at Carol's will. Carol said she knew that she had an interest in this and that she placed it in a trust for Nancy. And then after that trust was, after she died, it would be, after Nancy died, or after 7 years, it would go to the Wisman brothers. And you need to also consider, Your Honor, that in that will that George Wisman prepared, it was consented to by his wife. And just as plaintiff's counsel has pointed out, there is some devises or devises to Wisman brothers. But I think, and I believe, and I think the court believes, that all that it does is show that there is an intent that the Wisman brothers have this property. And if you also go to paragraph 8, and I don't know how the plaintiff can interpret this to mean only siblings of George Wisman, when it says the real estate cannot be sold to anyone but family members without first offering it on the same terms and conditions to family members. My interpretation of that would be that if anyone down the road ever inherited something from George Wisman, if they wanted to get rid of it, they had to offer it to other family members. And that again shows that his intent is that this farm was going to be farmed and was going to be owned by the Wisman brothers. Further intent showing that this was the plan is, look at Berdina's will, or even before that. Berdina sold all of her cattle and sold all of her farm equipment to the Wisman brothers. Now, why would she do that if they weren't going to get this farm? That was the only reason. The only case that is even close to this one is that Nickel case. And again, you don't have to put down what happens after someone dies. All you need is the life estate itself, which vests in the remainderment immediately. It's our belief that Nancy would have an undivided 1/6 in fee simple from her dad, George. The rest of it, the interest of Carol, is in trust for 7 years, and then that interest goes to the Wisman brothers. And then Berdina's death, she required that Darren's wife convey her interest, which was in the Wisman farms, to her sons within 30 days after her death. That was done as well. Berdina also would have agreed that George's will immediately vested an interest in the future interest in the heirs and devisees of Darren. Your Honor, I think what it shows is that Nancy would own 1/6, and 2/6 is in trust, and then the balance of the total of 5/6 is in the name of the Wisman brothers, and 1/6 in the name of Nancy B.A. Nancy B.A.'s interest would be subject to paragraph 8 of George Wisman's will, which requires her, if she wants to sell that 1/6 interest, she has to offer it to family members first. Wisman brothers are also family members. That's all I have, Your Honor. Again, relying on my brief for the purposes of this argument. Thank you.
Mr. Manson.
Judge, I don't think that it's appropriate to refer to events, wills, documents, transactions that occur decades after Mr. Wisman's will and decades after his death as reflective of the interpretation of his will. What Berdina did is what Berdina did, and that's a separate matter. She owned half of the property, and how she handled that is separate. So it would be incorrect to look forward. If you do have copies of Berdina's will, which Ms. Brin drafted, and you have copies of the Wisman Family Trust and the amendments to it that Ms. Brin also drafted, those do, I think, accurately reflect the intent of Berdina Wisman, but it would be improper to go back in history, go back in time, look into the future. I mean, it's almost science fiction then to say, well, because this happened out in the future, then this was predicted or was a predicate that was a part of George Wisman's will. That's just not the case. What you would really, well, I mean, if they wanted to make that argument, they really needed to look at whatever Berdina's estate planning documents looked like at the time that George died. But I don't think anybody has that, and I don't think that any of that's relevant. The other thing that I want to clarify, just so that the court doesn't get these terms mixed up. Mr. Hoffman refers to the Wisman brothers. There is a defendant that is Wisman Brothers. That's an entity. It's an entity, a business that operates the farming operation out there. One of the brothers, Galen Wisman, is not a member of that entity. So there wasn't an intention to leave it to Wisman Brothers. I don't think Mr. Hoffman's intentionally trying to confuse anybody. I think he's referring to Wisman Brothers as the three Wisman boys that are the sons of Darren. But there wasn't anybody's intent that this property be left to an entity, Wisman Brothers. Clearly, Berdina wanted to make sure that Darren's sons continued to farm the property that they inherited from her, but she didn't have any control after she died over the property that was left under her husband's will. And then, of course, the argument that all of this farm was to be left to the three Wisman sons of Darren, the three Wisman brother boys, sons, just isn't correct either, because an undivided fee simple interest is left to Nancy B.A., and she's not a farmer and a part of the farming operation. Whether she's obligated to sell it to the boys or not under the will and in the title is something we can bridge we can cross at another time. But that's my response.
Mr. Manson, I understand your argument, but I disagree with it in George's will. George could have required the children to outlive their mother in order to take. He didn't do that. He could have specified any other conditions for requirement to take, and he didn't do that. What he clearly says in his will, in paragraph 7, after he gives the life estate to his wife, he gives the remainder, and then he names his three children, Nancy Bea, Carol Wisman, Darren Wisman, and gives them each the 1/3 interest of his property, which is 1/6 of the total. And there's no requirements beyond that. So it is clear to the court that upon the death of Berdina, each of their children got 1/3 of George's property, which he passed on, which would be 1/6 of the total. And so Nancy Boya owns that 1/6. And then Darren and or his heirs own that 1/6. And Darren has passed, so it's moved on. And then Carol, her estate documents controlled that 1/6. What Carol did was place the property in trust for 7 years, where her sister Nancy gets the benefit of the income for the 7 years. And then it passes on to the 3 grandchildren. The 3 grandchildren of George and Berdina, which I think Mr. Hoffman has been referring to as the quote, Wisman brothers, meaning the 3 grandsons. Now, Berdina obviously created more requirements when she passed her property on, drafted by a different scrivener in her estate documents. She placed it into the Wisman Family Trust, which then gave Nancy basically a life estate. And then it passes from Nancy back to the grandsons and to Carol, and then Carol's will passes it on to the grandsons. And obviously, we have not reached that 7-year mark. And the parties can work that out. But George passed his half, or his 1/6 to each child, to his 3 children. So Nancy has a 1/6, Carol has a 1/6, Darren has a 1/6. And when the 7 years are completed, Carol's 1/6 goes on to the grandsons.
This is how math class felt. I'm not good at fractions, and neither are you.
Your decision is very clear, Judge. That's helpful to the parties, whether we agree or disagree.
Let me look back through the petition now and make sure there's nothing else that we need to deal with today.
You
So,
were very clear, Judge.
under
No
your
beating
order.
around the bush.
The Wisman brothers would have 4/6, and then after 7 years would have 5/6.
Yeah, for sure, Carla. All good.
Right now, they have, yes, because Leola
They don't
did
give the other.
what
Okay.
Verdina asked Leola to do, and that was to bypass her and pass all of her and Darren's interest onto the children, or the grandchildren of the original George and Verdina. Yeah, Darren's has all vested, Darren's interests have all vested down to the,
Did Holly find your search history, William? There's also a no contest clause in this case. Also, Cellulite Yoga Pants, can you help Carla add her channel with a command, please? And I cannot still believe that this is sped up, y'all. Sped up. Oh, Carla, it's all good. I wouldn't even care if you posted court. We don't care. I just can't add it while I'm live, 'cause I really don't know how. Just like with the fractions. I'll just get someone else to do it. That's what I did in math class. I copied a lot. I did allegedly devise some alleged. Never mind. I'm not even going to say it.
his sons.
I agree with that under the court's order. I disagree with Mr. Hoffman's math. As it stands right now, Nancy VA has at least a 50% interest in all the property because she has
She-
her one. Go
She
ahead.
has a 1/6 in fee.
Yes, sir.
She continues the life estate from Carol. And then that will pass on, and she continues the life estate as far as the farm, I believe, that, or the house that Verdina basically left to her.
Well, the property, all the farm property went into the Wisman Family Trust, so Nancy's the income beneficiary of that.
She still has the income beneficiary during her life estate.
Yes, yes, sir. So that's what I'm saying. She has a 50%, a 1/6 interest in all the property outright, absolutely, but then another 1/6 interest through Carol as a life estate terminating in 7 years, and another 1/6 interest, so that would add up to 1/2 through the Wisman Family Trust that terminates at Nancy's death.
But only as far as through the trust, she only gets the life estate.
Yeah, I understand that,
So
but it is a trust.
I would disagree with the language that she owns it outright. She doesn't. She has the life estate during her life, and then it will pass on to the 3 grandsons.
She,
I meant that she owns her 1/6 interest outright.
She owns her 1/6 outright.
and then she's got 1/6 in interest from Berdina and 1/6 interest from Carol. So yeah, you're right. 3/6 right now.
That's right. And then what, if we want to deal with this today, my argument would be Carol's trust, because it terminates in 7 years, we can calculate that income for those 7 years and that can be paid to Nancy. But as to the Wisman Family Trust, that trust is subject to trust obligations. And so that would have to do with whether the trust ownership of nothing but farm ground, as opposed to securities, treasury bills or bonds or other predictable and secured instruments. There are prudent investor rules that go to trusts. And so the trustees are obligated to protect that property. It may not be that just having the Wisman Family Trust vested in farm ground is the proper trust decision. So that's my position there. It may be that owning some farm ground is okay, but I'm not sure that owning all the farm ground. I think what we would prove evidentially is that the farm is a losing proposition, and that there is a lease in place. Whether I'm not sure that I agree that it's properly in place, but let's assume that it is. It terminates, I believe, at the end of 2026 or 2027. So when that lease terminates and they have no absolute right to re-up that lease, then should the trust be vested entirely in farm ground as a matter of trust investment policy? So that's the question that I have there.
Well, I think
And we
that's,
could talk about
I think
that.
that's to be left for a different day.
That is a different day.
As I understand the trust, that's up to the discretion of the trustees at this point.
I think that it is the trustee's obligation to make that decision.
Right, it's their discretion and their obligation, but it lies with the trustees at this point. To
Correct,
preserve
to make prudent and
prudent
accurate
investor, et cetera, to pass it on when the time comes.
Correct. I agree.
So are there any further findings you need today, Mr. Manson?
I can't think of any, Your Honor.
Any further findings you need today, Ms. Brent?
No, Your Honor.
Any further findings you need today, Mr. Hoffman?
No, Your Honor.
Anything else to preserve your record, Mr. Manson?
I don't think so, Judge.
Anything else to preserve your record, Ms. Brent?
No, Your Honor.
Anything to preserve your record, Mr. Hoffman?
The only thing is, I would point out that you now have the full and complete document of George Wisman, and I'd want that to be a part of the record.
Yeah, and that will be added. I will forward that to Linnell to add, because it does have language that was not in the record previous.
Now, that is a court filed document. I think the court can take judicial notice of that. It is in the record.
As far as the journal entry, as a large part of this is now on the trustees of the trust, Ms. Brand, I'm going to request that you do draft the order, circulate that to Mr. Manson and Mr. Hoffman, and give good guidance to the trustees.
Okay.
Okay,
They must have so much money, I guess, because imagine all these lawyers talking about this in front of a judge.
that we are adjourned.
Thank you, Your Honor.
Thank
Good
you,
luck-
Your
good
Honor.
luck to the family, keeping as a family in this matter, and including the wishes of George and Berdina.
Thank you, Your Honor.
Thank
Does
you
the
all.
court wish to set this for a further hearing, a status conference, or just to determine what other issues need to be resolved, or
No, bro, file a motion. File a motion. Motion of the ocean. File a motion. Get off of my screen. Sorry, I can't stand him. I literally cannot stand him. Should we do a little palate cleanser before we say goodnight? I think we should. I think we should just do a little palate cleanser. Just maybe like a little agreed upon divorce, perhaps? Just a little divorcey divorce? A little splitty? How does that sound? A little one, huh? Oh, that one's too long. There we go. This one. This one. Here we go. Then we'll say good night and goodbye. It's still light outside.
Is this everyone?
This is everyone, and I'm probably going to just make an announcement.
First announcement, sir, this is not a Wendy's. Is he at the drive-thru, or does he just really like Wendy's? What do we think?
Okay. This is in the District Court of Ellis County, Kansas, case number 17 DM 137. It is Karsten and Elena Montgomery by and through Cassandra Brockman versus Ryan Montgomery. And you're Ryan Montgomery?
Yes, sir.
Okay.
Okay, well, my dumbass thought this was a divorce. It's not, unless it's like a triplet divorce. They don't have those in Kansas. So I'm going to go ahead and just guess this is a different kind of lawsuit. By the way, tomorrow we'll be better prepared because I'll be home all day recording court. Yeah, Julie has quite the cool haircut, doesn't she, Mikey? I really like Ryan's shirt. You know, it was between that and a girl wearing a Dunkin' Donuts hat. I know she was... Actually, let's just watch her get divorced. That's what we'll do. Pretty sure she rolls her eyes. Plus, this way you can actually knock off a ceiling fan and work uniform, but appearing from car.
Good morning.
Off of your bingo cards, guys. Credence and Mikey. Mikey appearing is also on some of your
Morning.
bingo cards. Hit that
Morning.
one. Oh, green hair. We have a green-haired appearance in court. That's
There we
also
go.
on a bingo card.
Okay. You're Leonard Labarge
Yes.
and you're Emily Labarge?
Yes.
Okay. I'm going to swear you both in. That's the easiest way to go through this. So I'll start first with the case caption. This is in the District Court of Ellis County, Kansas. It's in the matter of the marriage of Leonard Jean Labarge Jr. and Emily Ann Labarge. And you're Mr. Leonard Jean Labarge Jr.
Yes.
You would raise your right hand, please. You solemnly swear and or affirm that you will tell the truth, the whole truth, and nothing but the truth, subject to the penalties for perjury in the state of Kansas.
Yes.
Thank you. You're currently in the state of Kansas?
Yes.
Thank you. You can put your hand down. And you're Miss Emily Ann Labarge?
Yes.
You would raise your right hand, please. You solemnly swear and or affirm that you will tell the truth, the whole truth, and nothing but the truth, subject to the penalties for perjury in the state of Kansas.
Yes.
And it's my understanding you're in Illinois right now,
Yes.
and you're subjecting yourself to the jurisdiction of the state of Kansas for the purpose of your testimony in this hearing?
Yes.
Thank you. You may put your hand down.
He's in Illinois for business with Duncan.
Okay.
My hand's dirty. What is that? I gotta wipe it off. Oh, it's Sharpie. I have a bad habit of uncapping Sharpies in my pocket.
And Mr. Labarge, you filed a petition on March 13th of 2025.
Yes.
Okay. And Miss Labarge, you entered your voluntary entry of appearance on that same date.
Yes.
Okay. And you were married on June 7th, 2014.
Yes.
Yes.
Okay. And Mr. Labarge, do you believe the parties are incompatible to the point that you need a divorce?
Yes.
And Miss Labarge, do you believe that the parties are incompatible to the point that you need a divorce?
Yes.
The court will grant the divorce based on incompatibility. Your divorce will be final today, but either one of you could file an appeal within the next 30 days. So do not remarry within the next 30 days. And if either one of you do file an appeal, don't remarry until after that appeal has been finalized. Okay?
Okay.
And neither of you are on active duty with the military?
No.
Okay.
She's deep undercover with Duncan for the military.
And Mr. Labarge, you paid the filing fee in this matter?
Yes.
And you're not seeking any reimbursement?
No.
Okay. And Miss Labarge, you're wanting to change your name back to Emily Ann Long?
I mean, if I can just keep it, just for the presence of it being easier for right now.
It's not like a plant or a dish that you plan on giving back later. It's a name, ma'am. You have to make a decision. You're entitled to it. You got married. You don't have to give it back. But it's not really a negotiation. You just have to tell them what you want. Okay?
I could keep the Labarge, if that's possible.
It's fine. It's totally up to you.
Okay, I'll just keep the Labarge. It's just a bigger hassle to change it.
I will white that out and you will remain Emily Labarge.
Okay. Is that okay with you, Lenny?
Yes.
Aww. That's so sweet. That's actually cute. Aww.
Okay. And the two of you entered into a property settlement agreement on your property.
I always have to remind myself about the property value in Kansas.
And Ms. Labarge, you were able to review the proposed settlement agreement?
Yes.
And does that appear to be the
Jesus
document that
Christ,
you've signed?
Judge, I need you to calm down for a second. You're sharing screens without... Oh my god, my phone. Sharing screens without giving me any notice, first of all. Second of all, I legit thought that... I forgot I had downloaded this, so it's already here, but I thought that it was stopping playing, and I was like, no! No! I can't even read it, though. But they seem to get along. Maybe they're going to get back together. Actually, let's just root for them. She's keeping the last name. Maybe they're going to get back together.
Yes.
And I want to run through that briefly with you. Okay.
Okay.
Now, there's a residence over in Victoria, and that is going to Mr. Labarge.
Yes.
Okay, and he's assuming all the debt on the residence.
Yes.
Okay. Is there any equity in the home that needs to be divided?
No.
Okay. And you've agreed to a parenting plan regarding your daughter?
Yes.
And is she 14 or is she turned 15?
She's 14.
14. Okay. And you've reviewed the parenting plan?
Yes.
Okay.
This is what's worked for us the past couple of years, so.
And you believe that's in the best interest of ARL, I'm sorry.
Yes.
Okay.
That's what we've noticed that she thrives with, so that's worked for us.
And you've got the holidays divided out.
Mhm.
Okay. And
So sweet, Carla. I'm glad y'all are here. We have a good time.
your settlement agreement and your parenting agreement call for no child support.
Yes.
Are the two of you sharing the expenses?
Yes.
Yes. We split 50-50, everything.
Okay. And you believe that's fair, just, and equitable?
Yes.
Okay. As far as your property settlement agreement, you've divided out your debts.
Yes.
And do you believe that's a fair, just, and equitable division of your debts?
Yes.
Yep.
I procrastinated changing my last
And
name
all
when
the
I
personal
got married so long that I actually got divorced before some documents required being changed. If you can imagine that. So there were some documents that like outlasted my marriage, technically. Gotta love that procrastination.
property has already been divided.
Yes.
And Miss Lavarge, you already have your personal property with you.
Yes.
Is there any property that Mr. Labarge still has that needs to be transferred to you?
No.
Okay, and same for you, Mr. Labarge?
Yes.
You've got all your personal property?
Yes.
Okay. Court finds your property settlement agreement to be fair, just, and equitable division of your assets and your debts. Court has reviewed your parenting plan and finds that it is in the best interest of your daughter. And the court will approve your parenting plan as you have filed it.
Hmm.
What the fuck was
And
that
both of
noise?
you are responsible for your own debts since the time of separation, February 1st, 2019.
Yep.
Okay.
They waited about as long as I did to finally get divorced, too. That's like 6 years. Good night,
Residence in
Carla.
Victoria will go to the petitioner, subject to the indebtedness therein.
Looks like Colin's live after this, so I've set this up to redirect over there. He has some witness tampering thing going down. Oh, shit. We can also pray collectively for a chase. Oh, the air is ripe for a chase in LA tonight. I feel it. I feel it.
And neither of you are asking for maintenance from the other?
No.
I include a chase prayer in all of my prayers. Always, baby. Can you imagine if Cringy Kometz was doing this one? What kind of jokes we'd have to listen to? He would definitely crack a joke about donuts, about so much. But Adam might be right. It is faster to stay married than to divorce in front of this judge. They might just want to live it out, you know? Bill, if it's in California, it should be called a follow. That's true. They don't really chase. A lot of following, some gentle tapping. A little love tap, baby love tap.
Is there anything else we need to
By the
deal
way, I
with,
want to be
Mr.
clear on
Labarge?
something. I respect
Nope.
the hustle of working
Ms.
anywhere.
Labarge.
Nope, I'm good.
Okay.
So I don't want anybody to get the wrong idea just because she shows up from her car with her work hat on. I get it, girl. Get it. I will enjoy my walk, Billy. I'm gonna try and hit 20,000 steps today.
Taking out the order for the name change.
Checking for her boss over her shoulder. No, Courtney, she's actually in the drive-thru right now, and she's checking to see how big of a lineup she has. But there was nobody inside to cover her, so this is the only way she could figure out how to come to court. Judge is going to say, okay, you're divorced, but don't get remarried within 30 days because one of you could file an appeal unless they sign a waiver. And
Signing off on
What?
your
What I missed,
parenting
Judge?
plan and custody agreement.
afternoon divorce break is breaking my YouTube.
That's your worksheet. It appears to be filled out correctly. And there's no need for the KPC.
No need for the
At this time.
KPC. Judge, please.
Okay,
oh,
remember
please.
your divorce is final as of today, but either one of you can file an appeal. So do not remarry in the next 30 days. If an appeal is filed, do not remarry till the appeal is finalized. Okay?
Okay.
Any other questions, Mr. Leonard Labarge?
Nope.
Any other questions, Miss Emily Labarge?
No,
Okay. Well, good luck to both of you. Make sure
thank you.
Make sure you continue to make good decisions regarding your daughter.
Yes.
Yes.
Okay?
All right. Thank
Thank
you.
you. Thank you all.
All right. Thank you.
Some of
Bye.
the most
You are-
adult decisions we've actually seen, I'll be totally honest, I have seen adults act way worse in court. They were perfect. That was incredibly boring, to be honest, because the only problem is that Emily now has to cancel her marriage that was scheduled in 12 days to her Dunkin' Donuts coworker. No, I'm joking. I wasn't invited to the wedding, so I don't know. Anyways, I hope that you guys had a good night. I'll be back tomorrow. It'll be afternoon, evening. I mean, it's the afternoon my time, evening your time. After like 4 o'clock probably. Anyways, do me a favor. Remember that I love you and I'm proud of you, and I will see you in the next video. Okay, bye.
Wisdom.